नमस्कार दोस्तों, हमारे शॉर्ट हैंड लैब प्रयागराज चैनल पे आप सबका बहुत बहुत स्वागत है। मैं आपको लीगल डिक्टेशन प्रोवाइड करूंगा जिसकी स्पीड होगी 100 to 110 वर्ड्स पर मिनट। 607 वर्ड की डिक्टेशन है। आप लोग रेडी हो जाएं। स्टार्ट। द लर्नेड जजेस ऑफ द डिवीजन बेंच आर आल्सो ऑफ द व्यू that the full bench judgment of the Allahabad High Court in Raj Bahadur Yadav versus State of UP, 1998 CRL.LJ 103 under bracket FB bracket close, also cannot be said to support the view expressed by the two earlier division benches of this court in the matters of Selvaraj and Radhakrishnan mentioned above. Full stop. However, the division bench, after adverting to the arguments of the learned counsel for both and the decisions cited, had observed in the middle of paragraph 12, that the question of making a representation to the advisory board has not been considered at all either in Amir Saad Khan's case 1991 under bracket 4 bracket close SCC 39 on in Kamlesh Kumar's case, 1995 SCC under bracket CRI dot bracket close 643 full stop paragraph. The learned counsel for the detainees contended that the advisory board would certainly be one of the authorities which is competent under law to revoke the order of detention, and thereby it can give relief to the persons detained. Full stop. Therefore, the non-mention of the fact that the detainee has a right to make a representation to the advisory board direct, vitiates the order of detention, as according to him, the observation made by their lordships of the Supreme Court in Kamlesh Kumar Ishwardas Patel versus Union of India, 1995 SCC under bracket CRL bracket close 643, extracted above, makes it obligatory on the part of the detaining authority to apprise such a right to the detainee. Full stop. According to him, it is not sufficient to state in the detention order that the detainee has right to make his representation in writing addressed to the Chief Secretary to Government, Chennai-9, and that any such representation made by him to the Chief Secretary will be placed before the advisory board for consideration of his case, and that he is entitled to be heard in person by the advisory board. Full stop. Apart from the above, the detainee ought to have been apprised that he has got a right to make his representation to the advisory board also for consideration. Full stop. It is urged by the learned counsel for the detainee that the advisory board is an independent body and is competent to give immediate relief to the detainee, and if he had been apprised that he has a right to make a representation to the advisory board, the detainee would have submitted his representations to the said body with different set of averments than submitted to the Chief Secretary. Full stop. According to the learned counsel, the choice is left with the detainee to make different sets of averment to be submitted to the Chief Secretary and to the advisory board. Full stop. Paragraph. In the above circumstances, it has become necessary to ascertain the authorities which are competent under law to revoke the order of detention and give immediate relief to the detainee, as representation has to be submitted to the authority which is competent to revoke the order of detention. Full stop. In support of the above contention, reliance is placed by the learned counsel for the detainee on a decision of the Supreme Court in Amir Shad Khan versus El Hamingliana and others, 1991 under bracket 4 bracket close SCC 39 full stop. In para 3, it has been observed as follows full stop. Paragraph. The law of the preventive detention is harsh to the person detained and therefore there can be no doubt that it must be strictly construed, article 22 under bracket 3 bracket close under bracket B bracket close denies to a person who is arrested or detained under any law providing for preventing detention the protection of clauses under bracket 1 bracket out and under bracket 2 bracket out of the said article full stop. Clause under bracket 4 bracket out thereof enjoins that the preventive detention law must conform to the limitations set out thereunder full stop. Clause under bracket 5 bracket close of article 22 reads as under full stop.